So today's newsletter dated 3rd April 2024 of the Supreme Court. The first news is that Supreme Court has quashed an FIR against a man who has been implicated in a 16 crore rupees cheating case and he was implicated under the section 415 and 420 of the IPC. And here the Supreme Court says that when there is no direct inducement or direct misrepresentation, or there is a deception from the very beginning by the person, then the particular section cannot be used even in the case of criminal conspiracy. So in this particular section, actually what happened, that this particular dishonest intention was there for the other two accused, but this the third accused, she did not have any kind of intention to commit fraud. So basically whatever in the said transaction, this person has executed whatever it was required as in a normal course of business it was required. So Supreme Court says when there is no intention or there is no continuity with the particular offense, they might be the part of the transaction, but they cannot be implicated simply because they are part of the transaction, because he did not have this particular illegal inducement, or neither he has cheated the person directly. So even under the criminal conspiracy, this section would not apply if there is no direct intention and the inducement to commit this particular fraud from the very beginning. So this section is very, this particular case is very important in this regard. Now in the second news, the Supreme Court has again reiterated that there is a particular section 14 subclause 2 of the Limitation Act, where it says that when a genuine litigant is spending time in a particular wrong forum where he has instituted a particular suit, and in that particular case, if the court directs that the suit has to be filed in any other jurisdiction, that particular period has to be excluded from the time of limitation. Means he can, if the time of limitation is bars him from filing that particular suit in another forum, but that will be condoned because of the fact the particular person is a genuine litigant. But here Supreme Court has also reiterated one fact, that the first institution of that particular suit in the wrong forum also has to be part under the limitation. That means that the person has actually approached that forum within the period of limitation where this particular wrongful jurisdiction has happened, and in that particular case only this section will be applied. Now coming to the third news is that Supreme Court has in a particular case, it has gone into a very detail where the arbitration clause should be included in a particular contract or not. There is a lot of cases which has come before the Supreme Court where there is a reference from another contract, and by just taking reference of that particular contract where there is any kind of arbitration clause, the parties have forcefully come into arbitration in the present contract. So in this regard, Supreme Court has taken some landmark decisions reference, and as like a MR engineering case, and in this regard Supreme Court has said that they have to comply with the ingredients of section 7 subclause 5 of the Arbitration Act, which clearly prescribe the fact that not only the reference of a particular contract, but the intention to come into the arbitration proceeding has to be also clearly implicated in the current contract. Means like if there is another contract where in performance of that particular contract, there is a necessity for going into arbitration, or arbitration is specifically one of the, let's say, main norms of that particular contract, and that contract is being referred here as specifically for performance of this particular contract, then the particular clause can be also applied in this regard. Even there is not a special mention of that particular arbitration clause. But let's say if there is only mention of a particular contract just in reference to this particular contract, and in this particular contract it does not clearly also state that the jurisdiction and other clauses, in this regard in this current contract, it cannot be said that the previous contract's arbitration clause has to be imposed in this one also. So there has to be clear reference, and also the fact is that there should be a clear intention in order to comply with the arbitration norms, and then this particular arbitration clause will be applied in those particular contract where there is a reference of another contract. Now coming to the last particular news of today, in a particular criminal case, the Supreme Court has actually set aside a particular judgment of a High Court, where it said that when, this is a very technical ground, the Supreme Court has said that when there is a trial court has two views, that there might be two possible views, but trial court has chosen one view in order for an acquittal of a particular person, the High Court cannot go into the ambit of the other possible reason if there is no sufficient defect in the current reasoning of the trial court. Means let's say if there is a possibility that the person could have been acquitted and the person could have been convicted because on the two possibilities. And there is sufficient ground to believe that the person should be acquitted, and the reason is that particular order is well reasoned. The High Court cannot go into the ambit that why the person should be convicted and can convict in this regard. So in this regard, Supreme Court has set aside a particular conviction of a Madhya Pradesh High Court, and in this regard, this particular judgment is very useful because it encompasses and restricts the High Court's jurisdiction in order to challenge the appeal and other grounds for acquittal in a High Court. So that is the news of today. If anyone has any kind of issues or confusion, please comment in the comment box, and also subscribe to my channel for further daily news in this regard. Thank you and have a great day ahead.